Hello, everyone. It's been a long time since I presented a podcast. I'd like to thank Will and Sam Kellyso, who have done a fantastic job in my absence, to fill in and present some of the podcasts that you've been listening to over the last few weeks. It's part of our effort to try to excavate some of the old favorites from the BSR series, and we will also be doing some more podcasts. So thank you to Sam Kellyso and to Will for the work that they've been doing. I would also like to extend a special thanks to Natasha and Lorraine. They are the two young ladies who are behind the scenes. They work to make sure that you get this podcast. So you probably don't hear from them, but they're doing a fantastic job. Thank you. Anyway, I decided that I would do one podcast. Today, I've been doing a lot of recording of my lectures and I'm in recording mode. So I thought, well, why not do one podcast for the BSR? So I'm going to do one podcast on the critical review of the interviews for the Constitutional Court judges, which was done at the end of last month. So the BSR was a critical examination of the judicial appointments process as witnessed by members of the public during the public interviews of the candidates at the end of September 2020. It's an important process which defines the composition of the highest court in the country, as well as the leadership of the third arm of the state. To understand the importance of this, let me give you a bit of a background. One of the major changes that were introduced by the Constitution, which was adopted in 2013, was a new process of appointing judges. In the past, judges were appointed by the President after consultation with the Judicial Service Commission. The President had no obligation to follow the advice that he was given by the JSC. His only obligation was to consult the JSC, but he could choose to ignore the advice. What actually happened in practice is that the Minister of Justice was really in charge of the process. He is the one who went around scouting for judicial candidates among members of the legal profession. This included maybe speaking to his friends, speaking to friends of friends, maybe having a chat over dinner, over a beer, maybe at the club. And that meant that he generally picked people who were familiar to him or people who were familiar to judges who were already serving on the bench. So it was the minister who presented the candidates to the president, and it's fair to say that this system operated like some kind of old boys club, which is no wonder the judiciary was very male dominated for a long time. And therefore, to that extent, the process was elitist and it also promoted patronage. It was opaque, and the opaqueness and vagueness of the process made it very undemocratic and exclusionary. If you were not part of the circle of the Minister of Justice, then you were really not in the running. The new process under the 2013 Constitution followed the path that was set by South Africa and Kenya, among other peers on the continent. It requires judicial candidates to undergo a public interviewing process. It also allows members of the public to participate in the process by giving every citizen an opportunity to nominate a candidate of their choice and to observe the public interviews in a public process. That way, the process of interviewing judges ensures that the performance of the candidates is a public matter, no longer the preserve of elites in their closed clubs and boardrooms. As for the candidates, there is literally no place to hide, as they have to be scrutinized not just by the interviewing panel, but also by members of the public in the gallery, which has expanded to living rooms and to offices thanks to television and to live streaming technology. Therefore, Zimbabweans, both at home and in the diaspora, were equal participants in the process of interviewing judges. Public participation in the judicial appointments process fulfills the promise that is made in the Constitution, namely that judicial authority derives from the people. In this respect, the new process is more transparent and more accountable. It is also one of the major democratic achievements of the constitution-making process, to the extent that it allows the public to have a greater participation in the process of choosing judges who make up an important arm of the state. It's not the intention of this podcast to carry out a review of the performance of each candidate. The intention rather is to critique the process that was used and highlight areas that need improvement. Having participated in the crafting of the provisions of this constitution, it was interesting for me at a personal level to observe their implementation through the interview process. It was fascinating to gauge the extent to which the process fulfilled my own personal expectations as a member of the team that crafted these provisions. The BSR therefore, presented my observations on the extent to which the process met the promise of the Constitution, and indeed the promise that we thought we were making to the people of Zimbabwe. My first observation of the latest, most recent interviewing process was that the questions were too procedural. What I mean by this is that the interviewing panel was focusing a little bit more, if not too much, on issues of legal procedure. Questions may either be procedural or substantive. They are procedural when they focus on rules of constitutional procedure. In other words, what do you need to do in order to achieve this? What are the rules of entry to the court? These are procedural issues. There are substantive issues when they deal with the substance of constitutional law, the philosophy of constitutional law, asking deeper questions. These questions were tilted in favor of, procedure. They were very dry, very technical, and required candidates to memorize rules of how cases are brought before the Constitutional Court, which I don't think is the purpose of these interviews. While it is useful to know legal procedures, I don't think that legal procedures provide a good test for a candidate of the Constitutional Court. Such questions test the ability of a candidate to memorize rules of procedure, but they do little to help ascertain a judge's grasp of substantive issues of constitutional law. These procedures are provided for in the Constitution and in the rules of court. Even the most competent judge would have to refer to these rules from time to time. The key is not whether one can remember or one can memorize these rules in an interview situation, but whether they know where to find the law. So when the panel was asking about remedies where a magistrate refuses to refer a matter to the Constitutional Court on grounds that the application is frivolous and vexatious, and a candidate makes reference to the major case in that situation, it is clear in my mind that the judge knows where to find the law. There is no need to cross-examine the candidate as if he were in a court of law in a manner that suggests that the mission was to prove that the candidate does not know the law. I do not think that such an exercise was necessary. In some ways, the excessive focus on procedural questions was reflective of one of the weaknesses of the current Constitutional Court. It is that the court is too caught up in procedural matters and technical matters and therefore cases, really good cases which the court should consider, are often dismissed on technicalities. Two of the candidates referred to this as a problem. One of them was Justice Makarau. The other one was Justice Patel, who said one of the problems of the Constitutional Court is that it hasn't had enough cases because they are often dismissed at the preliminary stages by the Chief Justice or the Deputy Chief Justice. And I think Justice Makarau also talked about the problem of cases being dismissed on technicalities. With a Constitutional Court which is so caught up in procedural matters, it is perhaps not surprising that the interviewing panel was also too preoccupied with procedural questions. I don't think that they are a good test for judging whether or not a candidate is a good candidate for the Constitutional Court. So my own recommendation is that questions on procedure or procedural questions should really be very limited, should not be the main course. The second issue, second observation, concerned limitations regarding substantive issues. More significant, in my opinion, than attempting to test the memory of a judicial candidate is an inquiry into their philosophical reflections on matters of constitutional significance. In other words, you want to find out a judge's understanding of constitutional jurisprudence and their philosophical dispositions, their philosophical inclinations concerning matters of constitutional law. What are the candidates' views on fundamental moral and ethical issues such as abortion, such as the death penalty, such as the protection of property rights, such as rights of the LGBTQI community, issues to do with euthanasia, fundamental issues, controversial issues. But at least we want to find out what is the philosophical inclination, philosophical view of this candidate on those various issues. In other words, the questions should test not just a candidate's ability to memorize rules, but their understanding of the high principles of constitutional law. There were a few questions that attempted to address this issue, but they remained a huge deficit. I would have liked to see more. The first was the question that required an explanation on concepts of constitutional order, constitutionality, and constitutionalism. This question called upon a candidate to demonstrate a broad understanding of the high principles of constitutional law. Surprisingly, most of the candidates performed rather dismally on this seemingly basic question. A candidate for the position of a judge of the Constitutional Court should never struggle to distinguish the concept of constitutionality from constitutionalism, let alone to define constitutional order. It was disappointing that many of them did not seem to have a clue or an idea as to the distinction between these important concepts. So I guess it's important for me to explain it to those of you who are listening. Constitutional order. Let's start with constitutional order. When you refer to a constitutional order, essentially you are referring to a political order that is underpinned and defined by and complies with the constitution of a state. A military coup represents a threat to the constitutional order because it upsets the normal arrangements that are underwritten by a constitution, which is normally divides the state into three: the legislature, the executive, and the judiciary. The candidates had a ready example which they could have used in this case when the soldiers took to the streets, like they did in November 2017 in Zimbabwe, without the order of the commander-in-chief. They were in fact going against the constitutional order. Constitutional order is based on formalism. In other words, it does not adequately address the qualitative aspects of government. It simply looks at whether or not a government is based on a constitution. It could be a good or a bad constitution, but it is still referred to as constitutional order. Therefore, a constitutional order can provide the basis for both a dictatorship and a democratic political government or arrangement. A constitutional order may also provide a justification for a monarchical or hereditary government. The main appeal of constitutional order is stability and certainty, knowing who has power and whether that person or that group of persons have power on a legitimate basis. It is legitimate if it is in accordance with the arrangements which are provided for in the Constitution, whether for good or for bad. Hence, the call by both democracies and dictatorships to respect the constitutional order. Anyone who is in power wants to claim that they are there in terms of the Constitution, and therefore they are very strong defenders of the concept of constitutional order. In fact, realizing the presence of dissent or disagreement, dictatorships are typically always in defensive mode, regularly reminding citizens to respect the constitutional order. This explains why there are so many people in Zimbabwe who are charged with the offense of attempting to overthrow the government. These charges represent a political message to citizens to respect the constitutional order, however unhappy they might be with the government. Constitutional order is good for society, but it is even better for those who are in charge of state power. A good candidate in these interviews who would have explained the concept of constitutional order by demonstrating these nuances. Disappointingly, in my opinion, most of the candidates gave very dry, very functional, and very uninspiring answers. So let's move on to the concept of constitutionality. Constitutionality denotes compliance with the Constitution. When one is considering a piece of legislation, the question is whether it is compliant with the Constitution. Like constitutional order, constitutionality is largely a dry exercise that involves ticking the boxes, especially when one is focusing on the literal words of the Constitution than the purpose. Therefore, a very bad law, a law which leads to very bad outcomes, might still be adjudged to be constitutional if it is determined to be compliant with the Constitution. The exercise is very dry and mechanical. It is simply whether the legislation satisfies the requirements of the Constitution, whether for good or for bad. If the Constitution therefore authorizes dictatorship, laws that allow dictatorial rule would still pass the test of constitutionality. Why? Because it is complying with the requirements of the Constitution. It is ticking the boxes. Therefore, many dictatorships in history have all operated in terms of a constitution, and they have all justified their actions on the basis of constitutionality. Constitutionality is good only to the extent that actions should be in accordance with known rules in the Constitution. But insofar as it focuses on the formal requirements of a law as opposed to the qualitative aspects of a law, it is not very helpful. Like I've said, a democratic government can pass the test of constitutionality. A dictatorship, an authoritarian regime, a brutal dictatorship can also pass the test of constitutionality simply by arguing that they are ticking the boxes of the Constitution. Now, let's move on to the next concept, which is quite different. And this is why it was very disappointing that some of the judges did not even think that there was a difference between constitutionality and constitutionalism. So, what is constitutionalism? Constitutionalism goes further and deeper than the box-ticking exercise involved in constitutionality. Constitutionalism denotes rather a culture of limiting the power of the state. Constitutionalism refers to limited government, the set of constraints that are necessary to ensure that governmental power is not abused. These limits on power now extend to non-state actors as well, recognizing that they also have enormous amount of power which impacts citizens. Constitutionalism, therefore, is a culture of limiting the power of those who have it in order to prevent abuse. Constitutionalism calls on more than written laws. It appeals even to unwritten norms, to unwritten codes, to customs, to traditions, to conventions that govern the conduct of those in power, constraining them against abusing the power that they have. It is inexcusable, in my opinion, that candidates of the Constitutional Court were caught confusing constitutionality from constitutionalism, given how these are different. Some of them even thought they were the same thing. They are not the same thing, and this inability to make that distinction gave a very poor impression of the candidates. How does one intend to be a judge of the Constitutional Court when they cannot even make a distinction between constitutionality and constitutionalism? Understanding this distinction sits at the very heart of constitutional law. But it's not very surprising that some of the judges who are already sitting on the Constitutional Court were unable to make this distinction. Many of the judges of the Constitutional Court tend to lie in favor of constitutionality, focusing very much on technicalities than on the substantive aspect of constitutional law. They are more for constitutionality than for constitutionalism. Most of the judges mistakenly believe that they are actually promoting constitutionalism when all they are doing, in fact, is reaffirming constitutionality, which is quite a disaster. As we have observed, even in a dictatorship, there can be a fulfillment of conditions of constitutionality while failing dismally on the test of constitutionalism. Constitutionalism requires a more nuanced approach to decision-making than the very dry, technical, almost pedantic exercise of determining constitutionality. Any judge should be able to make a distinction between the dry exercise of constitutionality and the more fluid, more substantive, richer exercise of determining constitutionalism. The next question, which also tested the candidates' philosophical reflections on constitutional law, was the inquiry into the link between fundamental rights and freedoms and the rule of law. I thought this was a beautiful question. This question called upon the candidates to showcase their understanding of the concept of the rule of law, which is a key principle of constitutional law. A more nuanced response would have referred to the two conceptions of the rule of law, the so-called formal conception of the rule of law and the substantive conception of the rule of law. Let me explain. A formal conception of the rule of law is very dry, rather like constitutionality. It looks at the presence and requirements of the law. Under this conception, even a dictatorship can make a claim to be operating based on the rule of law. A substantive conception on the rule of law, on the other hand, requires the protection of human rights and compliance with international law. This is what the question was asking for, a clear articulation that the protection of fundamental rights and freedoms is a reaffirmation of the substantive conception of the rule of law. This is a version of the rule of law championed by one of the great law lords of the United Kingdom, Lord Bingham, who argued very strongly for the substantive conception of the rule of law. And this is a version of the rule of law that is much favored by human rights advocates, because it is a rule of law which includes the protection of human rights. It would have been interesting as a follow-up question if the Chief Justice had asked the candidates which version of the rule of law they prefer, either the formal or the substantive versions of the rule of law, because in my opinion, a preference would have given a fair indication as to the kind of judge that a candidate is likely to make in a court of law. Those who favor a formalist approach are likely to be more conservative in their approach, more positivist in their approach, while those who prefer the substantive version of the rule of law are more likely to be very liberal, more activist in their interpretation of the Constitution and human rights. As it is, we are none the wiser regarding the candidates. We know that some of the candidates do not even know the link between the rule of law and human rights, while only a few do. But even for those who do, we have no idea what their view is concerning the substantive or formal types of the rule of law. The interview did not test their ability to critically examine the concepts, and this would have showcased their philosophical dispositions on very important matters. Now, it would have connected very well to the next issue which arose in the questions, which was about judicial activism. As I've already pointed out, judges who favor a more substantive conception of the rule of law would have been more inclined towards activism than judges who favor a more positivist, a more formalist approach to the rule of law. I thought that the judicial activism question was important, but it also, some of the answers indicated that the judges did not seem to have a firm grasp of the history of the Constitutional Court in Zimbabwe. Even when it was still under the Supreme Court, the court has been described as having been activist, especially in the 1990s. There were quite a number of cases which came before the courts where the Supreme Court, operating as the Constitutional Court, was really taking a substantive approach, a very activist approach. For example, cases relating to rights of prisoners, against capital punishment, against torture, inhuman and degrading treatment, rights of women, for example, equality. I think that the courts were taking a very strong, a very activist, quite progressive approach. And it would have been interesting if the judges had shown their knowledge of some of these things, but this was sadly missing in their answers concerning judicial activism. It's also a question that called for a more nuanced analysis by the candidates, because while there is praise for judges who are activists, there is also criticism in equal measure. Critics of judicial activism argue that judges do not have a role in making laws, that judges should not make law, because usually when judges are activists, they tend to go outside their usual remit of interpreting the laws and declaring what the law is. The role of making laws should be left to the legislature. So there are those who criticize the judges that, look, they are unelected and they don't have a mandate of making laws. The job of making laws should be left to Parliament. They accuse judicial activism of encouraging judges to do what is undemocratic, and since they are also not accountable to the public, as the legislature is. The legislature is accountable to the public because they have to subject themselves to an election after every 5 years, where they can be voted back into office or they can be chucked out of office by the voters, something that judges don't have to fear. This was also, in my opinion, a great question for judges to showcase their views on the important issue for the judiciary. It's a pity that there wasn't any follow-up to the questions that were posed. I think that it would have been very interesting to see how judges would have given their more substantive philosophical views on the notion of judicial activism, whether it's good or bad, and also the extent to which it could be used by judges to either develop the law and the extent to which it might create animosity between judges and politicians in the executive and also the arm of parliament. Another issue for me was the lack of consistency and discrimination by the interviewing panel. Let me give you an example. There was an issue of abortion which was raised by the panel, but it was only raised in relation to two judges. Firstly, it was raised in relation to Justice N. Mary Goora, who came as the third candidate. The other two candidates who had come before her were never asked this question about their views on abortion, which raised quite a problem with a lot of people who were watching on social media. I think we raised concerns that this was discriminatory. Why were they asking this important moral and the ethical issue to a female candidate, a question that they had not asked to the two male candidates before her? We thought that this was unfair and discriminatory. Later on, perhaps the Judicial Services Commission may have got wind of the complaints that people were making on social media. They changed approach and they did ask the same question to one more male judge, Justice Patel. But what was interesting is that even though the Judicial Service Commission was trying to correct its error, perhaps, the Chief Justice only made it worse, because before Justice Patel could answer the question, the Chief Justice Balava intervened and he protected Justice Patel, or tried to protect Justice Patel, by saying that he did not have he was not required to answer that question. If he felt that it was improper to answer it, he didn't have to answer it. Now, if the Chief Justice had shown the same protection to Justice Goora, then that would have been fair. But he hadn't. He hadn't intervened to protect Justice Goora, a female candidate, from answering that very tricky question. But he was ready to intervene to protect a male candidate, Justice Patel, from answering the question. As it happened, Justice Patel was brave enough to answer the question, and he did, much to his credit. But it's just about the panel. It's unfair to apply such inconsistency on matters of such importance. I think there is also a need for the interviewing panel to reconsider its interviewing style. There were times during the interviews when the interviews resembled a disciplinary hearing without notice. It might have appeared so to, for example, Justice Bunu, who looked humiliated, and to some extent Justice Lashwayo, when issues were brought about their long-standing and unresolved cases. But I think it's a terrible indictment on the Judicial Service Commission and its leadership that senior judges have been sitting on cases for so many years. So yes, I think there's a problem there with those two judges, but I think the bigger problem is systemic. It's about the system that is failing to ensure that judges perform their duties according to the required standards. I think that it is important for the Chief Justice and for the panel to appreciate that it's an interview, it's not an interrogation. Bringing files to the interviewing panel as evidence of a judicial candidate's weaknesses, I think that suggests that the system is failing. They have to deal with that elsewhere. It's not for interviews to bring such issues. In any event, if you shortlist a person who has such shortcomings, then it says a lot about the interviewing system, which needs to be sorted. I also felt, as did many people who were watching, that the interviews themselves were quite poor. I think the quality of questions could be improved. I've already referred to some of the issues. But from a stylistic point of view, the questions were long-winding and usually were in more than one part. So you had 2, 3 parts, 4 parts to a question. That made it very difficult for the candidates to answer the questions or even to remember the questions. It was not necessary. The very first question by the Chief Justice was in 4 parts. And I don't think that it was necessary to have such a question. He could have asked his questions individually and the candidates would have answered without the challenges that we had, candidates having to ask for repetition of the questions. Very loquacious questioning. It wasn't necessary, and I think that it needs to change. My own suggestion would be to improve the qualities of these interviews is for candidates to be given an opportunity to make a short presentation on a constitutional topic of their choice, maybe for 10 to 15 minutes. It would give them sufficient scope to articulate something of interest to them and allow the panel and the public to get a good sense of what the candidate is about and can do. After all, as judges, they will be required to write and to present judgments. The interviews are not supposed to be a trap for candidates. They are an opportunity for them to present something that they would have prepared for, in a good way. And it's a good way to judge the quality of a candidate's credentials. I also think that the panel should embrace technology. Initially, there were 12 candidates who were nominated for these 5 positions, but eventually, by the time the day of the interview arrived, 5 had dropped out. Some of them apparently were out of the country, so they could not travel, thanks also to the COVID-19 pandemic, which caused a lot of problems for some candidates. But this could all have been resolved through using technology. Zoom interviews could be held, Panopto, Microsoft Teams. There's so many technologies out there which could be used to, achieve the same purpose, and there was no need for the face-to-face interviews for all the candidates. I think that the Judicial Service Commission should move with the times and should embrace technology, especially the world we are living in now has so many opportunities and there's no need to be confined to the physical interviews. Now, before I finish, I just want to comment on one important issue which I think is absolutely important for Zimbabweans or for anybody in any part of the world. Whenever an opportunity presents itself for members of the public to be involved in a public process, then I think that they should take it. It's one thing for constitutions to not provide avenues for public participation, but it's quite another if they do and people don't use it. In this case, Zimbabweans are entitled to nominate judicial candidates. Many people don't know that. You could be in Dotito, in Chikomba, in Bikita, or in Cholocho, or Nkai. It does not matter. You can nominate a candidate of your choice. As long as that candidate meets the qualifications required to be a judge, then they will be considered. So people should not sit back and not use their opportunities to nominate candidates. There were quite a number of people in some organizations who were complaining, for example, that there were too few women candidates on the panel. There were only 2 out of the candidates who were interviewed. Now, none of those organizations, none of those people nominated people, even though they had an opportunity to nominate candidates. So I think that people should take responsibility seriously and nominate when the law allows you to do so, when the opportunity to do so is there. For its part, I think that the Judicial Service Commission should be more proactive in encouraging members of the public to take part in nominations, and more specifically in encouraging nominations of female candidates. Serious organizations do adopt deliberate policies and practices that encourage public participation and the nomination of female candidates because of well-known previous discrimination. It is not enough to just make a broad call for nomination. So in my opinion, a statement like members of the public are encouraged to exercise their right to submit nominations. The JSC encourages the nomination of female candidates and to use social media, use broad advertisement, public education campaigns in traditional and social media would help in encouraging more people to have the confidence to nominate their candidates. Now, let me conclude by saying that this is the reason why Constitutional Amendment number 2 should be resisted. I've written in the past that the Zimbabwean government wants to change the process by which judges are appointed. What it would mean in this context is that the whole process that we witnessed, the one that I've just analyzed and critiqued here, would never have happened if the amendment that the Zimbabwean government wants to pass had already passed. Thankfully, it hadn't passed, and therefore it's a matter that is still under discussion, but Zimbabweans should resist it. The reason why we have these public interviews is that people get to know who the candidates are. They also get to participate in the process of choosing judges. They get to see the performance of those judges. These candidates cannot be appointed behind a dark curtain. It can't be opaque anymore. A candidate will either have to perform or they don't do well. If they don't do well, they fall out of the running. They have to be seen to be participating in a process that is free, fair, and transparent. And I think that people saw that there are severe weaknesses on the bench. I think it's important for people to know that. It's important for people to understand that. The idea that interviews embarrass or humiliate judicial candidates, I think it's absolute nonsense. I think that if anyone wants to be a judge of the Constitutional Court, he or she should have the courage to face an interviewing panel in public and to face the public. After all, they derive their authority from the public. They derive their authority from the citizens. So why should they be shy to be subjected to public scrutiny, before a public audience? So in my opinion, it is important for these judges to go through this process to make sure that they do what requires to be done and they demonstrate that they are worthy candidates for the job that they are applying for. There is a final issue which might affect the legality of the process of choosing these judges of the Constitutional Court. It is in relation to the part played by the current Deputy Chief Justice, Elizabeth Gwaunza. On 31 March 2020, the Constitutional Court held that Constitutional Amendment number 1 was unlawful because the process by which it was passed was in breach of the Constitution. Now, this is important because the Constitutional Amendment number 1 is the law in terms of which the Deputy Chief Justice was appointed to her current role, which means that if Constitutional Amendment number 1 is illegal, then her position is also illegal. Now, although the Constitutional Court back in March found that Amendment number 1 was illegal, it suspended the order for 180 days to allow the Senate to correct the error that had been made by its predecessor. The legality of this order, of course, has been previously questioned by the BSR, but this is not the place for it. What is important is to understand that although Parliament had 180 days to comply with the court order, it has been seen by Veritas, which meticulously tracks legislative processes, that the period for compliance expired before compliance had been achieved. The Veritas, this organization, states in its Bill Watch 63 of 2020 that the 180 days expired on 27 September 2020, and these interviews were actually held on the 28th, a day later, of September 2020. This means that by the time that the interviews were held, Constitutional Amendment number 1 was null and void, and therefore the position which was held by Justice Gwaunza, the Deputy Chief Justice, was no longer she was no longer validly in office. Now, this raises a significant question about the legality of the whole process, because she sat on the panel of the Judicial Services Commission. Now, some people might say, well, it doesn't matter, these are technical issues, but these are the important issues. These are fundamental issues. The court would never have made the judgment that it made on the 31st of March 2020 if it was not important. And it's very surprising that Parliament has not acted to deal with this issue or to resolve this issue when it had 180 days to deal with it. They might cite COVID-19, but I think it's a lame excuse, because a lot of other things have happened during that process, and these things should have been done. Now, it raises questions about the legality of the whole process that I've already spoken to, and I think it raises questions also about the rule of law. So, in conclusion, I think that it is important that Zimbabwe has a process of appointing judges using a transparent and open process, and that this has been encouraged since the Constitution was adopted in 2013, and it's just a pity that this is now under threat from a government that wants to change it so that the process will now be exclusively in the province of the president, without the public scrutiny that currently exists. Thank you so much. I hope you have enjoyed listening to this particular recording, this particular podcast. It's been a fascinating day. I've had so much recording to do. I just thought that I would take advantage of it and do one more. And I thought it would be for 30 minutes, but I think it was going on and on and on. And but it's been a pleasure. Since I haven't done many podcasts in the last few weeks, this hopefully more than makes up for it. And thank you so much. Continue to support Will, continue to support Sam Kaliso, Natasha and Lorraine for the fantastic work they are doing. And I'll catch up with you another time. Thank you so much. Alex speaking.